I'm Ashley Schluck, the Wyoming Traffic Safety Resource Prosecutor. The defense attorney will claim that the defendant was missing signs or symptoms when the DRE did his evaluation. This line of questioning focuses on the fact that his client did not have all of the expected signs of the drug category that the DRE identified in his or her expert opinion. We have to remember that this is no different than alcohol. Not every person is going to exhibit every single sign and symptom every time when drinking alcohol. This is variance upon people as well as variance upon individuals in different times when they drink. Remember that not everyone will exhibit all of the signs and symptomology of the DREA matrix every time. Like alcohol, as I've described, everyone presents drug impairment differently. The defense attorney will also try to offer alternative explanations for the signs and symptomologies observed by the DRE. Perhaps the most understandable technique for the jury, the alternative explanation line of inquiry focuses on everyday rationale for symptoms or signs that are associated with drug impairment. These alternative explanations can deal with sleep fatigue, stress, a traffic accident, mental conditions, or anything of that sort. In all impaired driving investigations, evidence of impairment will be countered by possibilities of other alternative behavior. Remember that the officer uses all the evidence available for them in determining whether to arrest the driver. The officer does not take pieces of evidence or a sign or symptomology in a vacuum. He determines everything as a whole picture and comes to the conclusion that every single sign and symptomology that he observed or she observed is consistent with drug impairment and not something alternative. The defense attorney will also claim and argue that the cop is just that, just a cop and not a doctor. This is set up by the defense attorney in opening statement or voir dire by asking the jury if he or the jury uses a plumber to do an electrician's job or vice versa. The DRE can shut this down if his instructors at his DRE school included medical professionals. On the other hand, the DRE has a ton of training in these medical measurements. They look at eyes, they take a person's temperature, and they take blood pressure. These are not advanced techniques and can be easily learned. We have to remember that we as a society take our own temperatures. We take our children's temperatures when we believe that they are sick instead of rushing them right to the doctors. We also take blood pressure to ensure that our own blood pressures are within normal range. The defense attorney will also try to challenge the chemical test. We're not going to go in depth into this in this segment, but we do want you to know that you need to contact your local lab to have a conversation with them about the chemical test results. Sometimes the chemical test will come up non-detected and will not match the officer's call on the category of drug impairment. We have to remember that we need to contact our lab professionals as there may be limitations and other reasons with the lab that this result was obtained. Most chemical test challenges will also be an effort to prevent admission of the chemical test, not necessarily undermine the science of that test. These challenges are also based on some sort of failure in administrative rules and regulations, that the officer had some sort of timing error, or that there was some sort of deficiency in the paperwork done by either the officer or the laboratory. Again, these are all very state and lab specific, so please contact your lab to discuss these issues. Again, we have to remember that these go to the admissibility of the chemical test results and not necessarily the weight of the evidence. Therefore, we have to argue that the chemical test result is admissible and that the jury should be able to give it the weight that it determines necessary. Please contact your other resources aside from your lab. You can contact the National Traffic Law Center or your local traffic safety resource prosecutor.